It's 9 a.m. Let's get going. Aloha mai kako. This is the February 24th, 21 Land Use Commission meeting and is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program. We're doing this, of course, to comply with the state and county official operational directives during the COVID-19 pandemic. Members of the public are also able to view this meeting via the Zoom webinar platform. For all meeting participants, I would like to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, it assists us if you state your name and identify yourself for the record. And please also be aware that for all meeting participants, this meeting is being recorded on the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record for this event. If you do not wish to be part of the public record, you should exit the meeting now. The Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. In part due to that, please note that due to matters entirely outside of our own control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know and please be patient as we try to restore the audiovisual signal so we can effectively conduct our business during the pandemic. For any members of the public who may be attending using only a phone, I will refer to using the raise hand function, and you can access that by pressing *9 on your keypad and then *6 to request to be unmuted. My name is Jonathan Likeke Scheuer. I have the pleasure and honor of currently serving as the Land Use Commission Chair. Along with me, Commissioners Axon, Chang, Okuda, and Wong, our LUC Executive Officer, Daniel Ordenker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, our Deputy Attorney General, Lauren Chun, our Program Specialist, Natasha Kananis, and our Court Reporter, Jean McManus, are all on the island of Oahu. Commissioner Nancy Cabral is on Hawaii Island. Commissioner Leo Higashi is on Maui, and Commissioner Dan Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9. I'll announce for everybody, though, while it was originally contemplated that we would be discussing the City and County of Honolulu's important agricultural land submittal on this date, we've had difficulties properly notifying all affected landowners, and that has resulted in us having to delay commencement of those proceedings. We will be rectifying this shortly, and we expect meetings to be rescheduled for the end of March. We apologize for any confusion this may have caused. With that, our first order of business is adoption of the February 10th and 11th, 2021 minutes. Mr. Hakoda or Mr. Derrickson, has anyone submitted testimony to comment on approval of the minutes?
Mr. Chair, this is Riley. No public witnesses on the minutes.
Okay. Are there any members of the public in the attendee portion of this hearing that wish to testify on the adoption of the minutes? If so, please raise your hand. Seeing none, are there any comments or corrections to the minutes, commissioners? Is there a motion to approve? Nancy Cabral makes a motion to approve the February 10th and 11th minutes. Is there a second?
Chair, I second. This is Commissioner Wong, second.
Thank you, Commissioner Wong. Motion's been made by Nancy Cabral and second by Commissioner Wong. All in favor, please say aye and raise your hand. Aye.
Aye.
Is anybody opposed? The motion carries. Our next agenda item is our tentative meeting schedule. Mr. Ordenker.
Thank you, Mr. Chair. As the chair just mentioned, tomorrow's meeting is canceled. On March 10th, we will be meeting once again by Zoom for the Hokua Place matter. On March 11th, we will also be meeting for the Hokua Place matter if necessary. On March 24th, I'm sorry, I have to correct this. On March 24th, we will be meeting to hear the Barry Trust closing arguments. On March 25th, we will hold our first hearing on the City and County of Honolulu's IAL presentation. On April 14th, you will be meeting to adopt the order in this matter, the Barry Trust matter before us today, and also to hear a declaratory ruling request, DR 21-71 from Maui, and hear a status report with regard to A11790, the Cooler Ridge District Boundary Amendment. On the April 15th, we will be hearing the continuation of either one of those matters or both. On April 28th, we will be hearing A07772, the Kamalani motion to extend time, and any further proceedings with regard to the City and County of Honolulu's IAL submittal. On April 29th, we also have reserved for the City and County of Honolulu's IAL submittal. On May 12th, we have the Pohakea special permit, and we also have, which is from Maui, and as well as on May 13th, and we will be hearing any IAL matters, City and County of Honolulu IAL matters at that time as well that may be outstanding. On May 26th, we have tentatively scheduled the AES West Oahu Solar a matter and important agricultural land matter continuation, as well as on May 27th. On June 9th, we will be hearing the Cooler Ridge matter, Maui matter, and we also have June 10th set aside for that. And that takes us through the end of June, Mr. Chair.
Thank you, Mr. Ordenker. I'll also note as an addendum to your notice of commission actions, one that will affect 3 of the commissioners is that on March 3rd, Commissioners Cabral, Giovanni, and Okuda are up for reconfirmation in front of the State Senate Waterland Committee.
Yes, thank you, Mr. Chair. That was actually going to be my next statement, and I was going to ask for time to
Okay.
notice that this is happening. We would appreciate any support that the other commissioners or members of the public would have for our commissioners seeking reappointment. Thank you.
Okay. Commissioners, are there any questions about our tentative meeting schedule? Seeing none, we can proceed directly to our main item of today. The next agenda item is an action item regarding docket number A18806, Barry Trust, Hawaii, an amended petition to amend the land use district boundary of certain lands situated at Kea'au, Puna, County and State of Hawaii, consisting of 0.51 acres of land from the Conservation District to the Agricultural District. Tax map key number 31-5-59, lot 59. Will the parties please identify yourselves for the record, starting with the petitioner?
Good morning, Chair Scheuer, Commissioners. Derek Simon on behalf of petitioners Kevin and Monica Berry, trustees of the Berry Family Trust. With me today, present also from our office, is Alicia Fung. She'll be helping out with a couple of exhibits. And Mr. and Mrs. Berry are also in the audience, and you'll hear some testimony from Mrs. Berry later in the morning.
Great. Mr. Simon, will that be during the public testimony portion of that, or you'll be calling them up as a witness?
I'll be calling Mrs. Berry as a witness.
Okay, thank you. Office Planning.
Good morning, Deputy Attorney General Brian Yee. On behalf of the Office of Planning, with me is Rodney Funakoshi and Aaron Setagawa from the Office of Planning.
Okay, Hawaii County.
Thank you. Good morning. This is John Mukai, Deputy Corporation Counsel on behalf of the County of Hawaii Department of Planning and the Planning Director. Also present is Ms. Maya Jackson and also Hawaii County Planning Director Zendo Kern.
Hello.
Aloha, welcome. Before we begin, let me update the record. On June 25th of 2020, the Commission met via Zoom to consider the petitioner's motion for issuance of a finding of no significant impact, or FONSI, and unanimously granted the motion. On June 30th, the LUC transmitted the determination of FONSI and a final environmental assessment with necessary material for the next publication of the environmental notice. Also on that date, the LUC received the petitioner's OEQC publication form. That's the Office of Environmental Quality Control publication form, the final EA, and a CD and a thumb drive of the final EA. On November 4th, 2020, the Commission received the petitioner's amended petition for the Land Use District Boundary Amendment along with Exhibits 1 through 16. On November 27th, 2020, the LUC mailed a deemed complete letter to the petitioner. On February 12th of this year, the LUC mailed out our February 24th to 25th, 2021 agenda to our statewide, Oahu, and Hawaii mailing lists. And on February 17th, the Commission mailed out an amended agenda to those same lists. The meeting notice and the amended agenda were also filed with the Lieutenant Governor's office and posted electronically to the Commission's website. On February 23rd, the Commission received the Office of Planning's testimony in support of the petition, the County of Hawaii's Planning Director's response to the amended petition, as well as the affidavit of Derek Simon and Exhibits A through E. Now let me briefly describe our procedures for this morning. First, I will give the petitioner the opportunity to respond to the Commission's policy regarding governing reimbursement of hearing expenses. I will then call for any public testimony on this matter. To date, no written public testimony from the general public has been submitted. I will offer the opportunity to members of the audience, the opportunity to submit oral testimony. People will be sworn in. If they wish to submit testimony, they can offer up to 2 minutes of testimony on this matter. And they will then be available for questioning by the petitioner, the County of Hawaii, the Office of Planning, and the commissioners. Following any testimony on this matter, I will close it, and then I will give the opportunity, if there are any additional exhibits on the record, to be offered by any of the parties. Following that, the petitioner will present their case. When the petitioner is finished with their presentation, they will be followed in turn by the County of Hawaii and the State Office of Planning. After presentations by each of those entities, they will be available for questioning by the commissioners. I will finally note that from time to time, approximately every hour, I will call for breaks as necessary, about 10 minutes every hour. Parties, are there any questions on our procedures today, starting with Mr. Simon?
None from the petitioners, Chair.
Mr. Mukai?
No, sir.
Mr. Yee?
No questions, thank you.
Okay. Mr. Simon, have you reviewed HAR 151545.1 with regard to the reimbursement of hearing expenses? And if so, what is your position on this matter?
Chair, yeah, petitioners are aware of and agree to the Commission's policy on reimbursements.
Thank you very much. Okay, I'm now going to see if there's any member. Oh, Commissioner Cabral, do you have a disclosure to make? Please proceed.
Yes, I may have made this disclosure, but we have new people involved with this case on the county level, at least. I wanted to disclose that at one point in time, approximately 20 years ago, I was appointed by the Third Circuit Court, Judge Nakamura, to serve under a temporary master receivership and was the property manager for all of Hawaiian Paradise Park for approximately 6 years. So I'm extremely aware of the subdivision and actually even that location. But I do not believe that that would have any effect on me because that's just one of 8,835 lots because I stuffed all those envelopes many times. So I'm okay if everyone else is okay with my situation.
So Commissioner Cabral, you're asserting that you can be fair and impartial in this docket?
Yes, absolutely.
Okay, I'm going to ask, are there any objections to Commissioner Cabral's continued participation? Mr. Simon?
None from petitioners. We're happy to have Commissioner Cabral.
Mr. Mukai?
None.
Mr. Yee?
No objection.
Okay. Are there any other disclosures from the Commission? Seeing none. Just final confirmation, Mr. Hakoda or Mr. Derrickson, has any written public testimony been submitted on this docket?
Mr. Chair, as of this morning, no testimony has been received.
Okay. Are there any members of the public who who are in the attendee function of this Zoom meeting who wish to testify on this matter, excluding the Berries who will be called in as witnesses. If there's anybody who wishes to testify, please use the raise your hand function on Zoom. If you're calling in by phone, hit *9 to raise your hand, and I will call you in and bring you into the main meeting. Going once, going twice. Seeing none, there's no public testimony on this matter. I'm going to close public testimony on this matter, and I'm going to allow Mr. Simon to begin with his presentation. Oh, wait, sorry. First, are there any exhibits in addition to any of the written filings that have been provided already from any of the parties? Mr. Simon?
Nothing additional for petitioners that wasn't filed as of yesterday.
Okay. Hawaii County?
No, nothing further.
Mr. Yee?
Nothing further.
Okay. Now you may begin, Mr. Simon.
Thank you, Chair, and good morning once again, Chair and Commissioners. Thank you very much for being here today. I want to thank staff as well for all their hard work and help in getting us to where we are right now. And I also want to thank the county and the Office of Planning for their support. I want to give a quick overview of the presentation we have planned today. I will start off with a presentation by myself. I'll give you an overview of the docket, the Hawaiian Paradise Park subdivision where the petition area is located, as well as the district boundary amendment being requested. I will then call Monica Berry, who's co-trustee of the Berry Trust and one of the petitioners in this docket, and she'll provide some more information on the project and other related items, and then we'll make ourselves available for questions after that. Today is really a big day and what's been a long journey for the Berries. They purchased the petition area back in 2007 while still living in California and still working full time with really a big dream of hopefully retiring one day to sort of this rural agricultural lifestyle that the big island of Hawaii offers and is so well known for. They're now retired and full-time Hawaii residents, and they're ready to enjoy their retirement years, and they think they found the place to do it. This docket was first opened back in December of 2018 when the commission agreed to be the approving agency for an environmental assessment and authorized the Berries to go ahead and file a draft environmental assessment. That process really culminated in June of this past year, June 2020, when the commission unanimously voted to issue a finding of no significant impact for the project and authorized publication of the final EA. That final EA was published in the July 9th edition of OEQC's environmental bulletin and cleared the way for the filing of the amended petition before you today, and then also this hearing. In our presentation today, we're not going to go into a ton of detail of the findings in the final environmental assessment, in part because the commission's FONSI is its own determination that the project won't have any significant environmental impacts. But we're, of course, more than happy to answer any specific questions the commissioners may have. Alicia, can you pull up Exhibit 10A for me, please? Bear with me for just a moment. I don't have a ton of exhibits, but a little shuffling here to get started.
Mr. Simon, can you slow down a little bit, please? This is the court reporter.
Yes, Gene, I apologize. I don't think it would be a hearing if you didn't tell me to slow down. So
Thank you.
I will do so. Okay, so what we have here is a tax map with a state land use district overlay showing Hawaiian Paradise Park subdivision. That's the subdivision there outlined in red. And you can see the petition area noted up there sort of in the top right-hand corner. All the green shading you see is agricultural district land, state agricultural district land. And then you'll see some small bits of blue along the shoreline, and that's conservation district land. And we'll talk a little bit about why that land is in the conservation district here in a minute. But first, I want to provide a little history on the sort of the history of Hawaiian Paradise Park and sort of the land use planning history to it. So Hawaiian Paradise Park was created in 1957 and includes, as Commissioner Cabral noted, 8,835 parcels. So it's quite large. It's actually the second largest privately owned subdivision in the country, and it's the second largest population center for the county of Hawaii. Hawaiian Paradise Park's in the Puna district, which is also the county's it's been the county's fastest growing district for about 30 years, and that's due in part to its proximity to helo and availability of land. Interestingly, when Hawaiian Paradise Park was created back in the late 50s, there was no land use commission, there was no chapter 205, and in fact, there wasn't even a county zoning code. When the commission was formed and chapter 205 enacted, the commission placed the entirety of Hawaiian Paradise Park in the agricultural district. And the overwhelming majority of Hawaiian Paradise Park has remained in the agricultural district ever since. However, in 1969, the commission conducted one of its 5-year boundary reviews. At that time, there was no chapter 205A, which is the state's coastal zone management program. That's where you get our special management area laws and our shoreline laws. So during its boundary review, the commission determined that it needed to make sure that the shoreline was adequately protected, and it actually placed all of these shoreline parcels on the coast here in Paradise Park into the conservation district. And again, the stated purpose of that was to protect the shoreline. We'll fast forward about 10 years, and a group of homeowners, all these homeowners of these coastal parcels were denied permits to build residential dwellings in this area by the Department of Land and Natural Resources because it's conservation district land, it fell under their jurisdiction, notwithstanding that several other owners in the area had actually been given permits. So there's a little bit of a flip-flop on the policy for dwellings in this area, and that caused basically all the homeowners of these lots to form the Paradise Hui Hanalike Association. And in 1976, they filed a petition, sort of an en masse petition with the commission to put all these parcels back into the agricultural district again, where they were when the districts were first formed. And interestingly, that the petition area before you today was actually included in that petition, but ultimately was removed after the owner at that time just couldn't be contacted. Obviously, back then, communications was a little different, and people weren't just an email away. So that's why we're here today. In August of 1977, the commission issued a decision and ordered and reclassified the vast majority of these parcels back into the agricultural district. So this is essentially the second time the commission determined that these coastal parcels satisfied the requirements for that, met the criteria for the agricultural district and were appropriate for the district. In its decision order, the commission highlighted several reasons for its decision. First, it noted that the stated purpose of that 1969 boundary amendment that was done by the commission through its 5-year boundary review. The purpose of that was to protect the shoreline, and now at this point, Chapter 205A had been enacted, and so we had a whole layer of regulation specifically addressing the coast and coastal resources. So the restrictive conservation district designation was no longer needed. Second, the commission noted, as you can see in this map, that virtually all of the lands around these parcels is in the agricultural district. We're talking thousands and thousands of acres of land, contiguous land, all in the agricultural district. Third, the commission noted that the parcels didn't have any special conservation value, not to say that coastal resources don't hold conservation value, but no special value that really required for these parcels to be in the conservation district. And finally, the commission found they found the situation unjust and inequitable, in their own words, that these homeowners are essentially very limited in their ability to use their land, virtually at all, unlike their thousands and thousands of acre neighbors in the Hawaiian Paradise Park subdivision. Interesting fact about that decision and order, and we'll kind of circle back this later, is the decision actually expressly notes that these petitioners were very upfront with the commission, said that they actually intended to use their parcels for purely residential purposes, notwithstanding that Chapter 205 then, as it does now, requires dwellings in the agricultural districts to be farm dwellings, and we'll talk more about that later. But anyways, notwithstanding that representation, the commission still found it appropriate to place these parcels back into the agricultural district. If you walk down Paradise Alki Drive, which is the coastal road there right now, and you walk by these parcels, you see a great significant number of them have since been developed with single family dwellings. And so that's really what this petition is about today. It's really just a request from petitioners to be put on par and be on the same footing as their neighbor and be able to use, make reasonable use of their land in the same way that people are able to do so, in the thousands and thousands of acres around them. I want to shift gears a little bit and focus more on the petition area and the requested boundary amendment. Alicia, can you pull up Exhibit 7? Okay, this is a bird's eye view of the petition area. It says Berry property, but that's the petition area there outlined in yellow. And you can see Paradise Alakai Drive right there. That's the road I just mentioned to you. And then you can see all these existing dwellings that have been built on these lots that were reclassified by the commission back in 1977, including the lot immediately to the north of the petition area. So as I briefly mentioned, the project proposed, the reason for the boundary amendment being sought is to allow the Berries to proceed with a farm dwelling and an associated agricultural use. The Berries, our intention is to build a modest single family home, in the neighborhood of 3 bedrooms, 2 baths, something that allow them to live, have an office, and maybe a spare bedroom or so for the occasional guest. They're not proposing McMansion. They're not pushing the building envelope to the maximum amount allowed on the county. It's really just a modest, simple home for them to enjoy in their retirement. The dwelling style and landscaping style will be consistent with existing neighborhood. You sometimes hear it referred to as sort of contemporary Hawaiian. And I think most people are more or less, familiar with what that means. The petitioners are hopeful that they'll be able to, inhabit the dwelling mostly off the grid. They're going to utilize solar PV panels, and they're hopeful that will provide all the power needed for their dwelling, but power is also available from the utility on overhead lines in the area. They're going to either drill a well on site or a catchment system for water, both of which are very common in this part of the county. And then they'll utilize a septic or advanced aerobic individual wastewater treatment system, as there is no municipal sewer service here in the area. For their agricultural use, the Berries will be implementing an apiary or a bee colony or bee colonies. And I'll actually have Ms. Berry speak a little bit more in detail on that. And she's really the one you guys want to hear about from that. But before we hear from Ms. Berry, I just want to go over the commission's criteria for the agricultural district. That standard is set forth in Hawaii Administrative Rules 15.15.19. And there's a couple of subsections. We're focusing on subsection 3, which says that the agricultural district can include lands that are either surrounded by or contiguous to other agricultural land, or lands that are not suited for agricultural or ancillary purposes for reasons of topography, soils, and other similar characteristics. And we do think that the petition area falls squarely within these requirements. First, as I discussed earlier, the petition area is surrounded by thousands of acres by other agricultural land, and it has been for a long, long time. Second, the soils are very poor at the petition area, and we'll talk a little bit more with Mrs. Berry about that in more layman's terms. But the two most important rating systems for the purposes of this request are the agricultural lands of importance to the state of Hawaii, or ALISH rating system, and the Land Survey Bureau rating system, or LSB system. Under the ALISH system, there's a number of different designations, from prime at the very top for the best agricultural lands, all the way down to unclassified lands that are determined to not be important agricultural lands for the state. And so the entirety of the petition area is unclassified under the ALISH system. Under the LSB, or Land Survey Bureau system, that's an A to E rating system, with A being the highest, most productive land, and E being very poor land for agricultural purposes. And the petition area is rated E under the LSB rating system. And third, the proximity of the parcel to the ocean does present additional challenges for agricultural activities, including because of the salt spray that comes off there. And as I think most of us know, there's lots of plants that don't like salt spray. So that includes my initial part of the presentation. At this time, I would ask that Ms. Berry, Monica Berry, be let into the hearing so we can do a little Q&A session with her and have her provide some more information for you.
Okay. Let me- So there's two Kevin Barrys listed in the
I know.
attendee section. Would the Monica Barry, Kevin Barry, raise your hand? Well, I have a 50-50 chance, right? Oh, I did the wrong one. Okay. They raised their hand right after okay. They're both gonna come in for now. If you would unmute and turn your camera on. If you're having any problem with doing it, the controls are often visible at the bottom of your screen if you move your cursor, depending on the device you're on. Okay, I see you're unmuted and I see a camera coming up. There you are. We can see you. Can you say something, please? Okay, we cannot hear you yet. No. However, nobody has a cat filter so far, so that's. I don't know if Alicia, Derek is working with the Berries or.
No, unfortunately, Alicia and I are here in Honolulu, and the Berries are on the Big
Island. Can you say something at least that we might hear you? You're unmuted, so it might be the volume control on your device. Give it a few seconds more. If not, Mr. Simon, I'm going to ask you to continue and while they try to get themselves visible and audible. Ms. Berry. Okay, in the interest of time, Mr. Simon, I'm going to ask you to continue, and then hopefully your witness will be available. I believe there is, if nothing else fails, there is on the instructions to the Zoom, meeting inability to call in. Connecting to audio. Can you wave if you hear me? Okay, great. We're partially there. Okay, you're unmuted. Yes.
Testing.
Okay, great.
All right, my apologies.
It's okay. This is not the first time since the pandemic started that somebody has had this problem. I'm going to first, Ms. Berry, I'm going to first swear you in. Do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay, now you will be questioned and give testimony in response to your attorney, Mr. Simon. After that, you'll be available for cross-examination by the parties and commissioners, if any. Mr. Simon.
Thank you, Chair. Good morning, Monica. How are you?
My heart's pounding a little bit, but I'm good.
Well, let's dial it down a little bit. You're here, and we're really glad to have you.
Thank you. Glad to be here.
Monica, I'm gonna call you Monica if that's okay.
Absolutely, yeah.
All right. So you are one of the trustees of the Barry Family Trust. Is that correct?
I am.
And who's the other trustee?
My husband, Kevin,
Okay, and is Kevin there with you today?
he is.
Okay. but
He's in
he's
the
not-
other,
He's in another room. Okay, he's not feeding you answers or anything like that, is he?
no,
Okay. And the Berry Family Trust is the petitioner for this docket, is that correct?
it is, yes.
Okay. Do you recall when we filed this amended petition, you signed what is called a verification, and in that verification, you attested to the truth and accuracy of the contents of the amended petition to the best of your knowledge?
I did,
Okay, and you signed that document, is that correct?
yes.
Okay, and is that still true to this day? Have you learned anything that's
Oh,
changed?
yes,
Okay,
no
Great.
changes.
okay. Monica, are you and Kevin full-time Hawaii residents?
We are, yes,
Okay. And how long have you lived in Hawaii for?
since 2017.
And what prompted your move to Hawaii?
We started visiting Hawaii in 2001, where we were raised in San Diego in California. And we took our first vacation to Hawaii, and we kind of immediately fell in love. So shortly thereafter, we started visiting every year. And around 2006, when we started thinking about our retirement options and how we didn't want to work anymore, we decided that we would plan a move to Hawaii to retire.
Okay. And what did you and Kevin do before retiring?
Kevin was a design engineer, and I worked for the San Diego County Superior Court as a staff attorney.
And where in Hawaii are you guys currently living?
We live in HPP. We're on Upper HPP on 28th Avenue.
Okay, and by HPP, you mean Hawaiian Paradise Park?
Yes.
Yeah,
sorry.
and I just want to clarify for some of the commissioners that may not be as familiar that you and or I may sometimes say HPP, and we're referring to the larger subdivision.
Yes,
When did you and Kevin purchase the petition area?
in 2007.
Okay. And when you purchased the petition area, you understood that it was in the conservation district?
We did. Originally, it was something we discovered through escrow, and even the owner at the time didn't know it was in conservation land, but we did. And during the escrow period and our due diligence, we talked to the county and several other people who told us that we could build a house there. We'd have to go through a special permitting process, but that it shouldn't be a big deal.
Okay. And so you understood that there was additional permitting requirements, and that's why we're here today, right?
Yes, that's right.
Okay. And so you and Kevin chose to pursue a district boundary amendment from the commission instead of a conservation district use permit from the BLNR or the DLNR. You want to provide any sort of explanation as to why you guys went the route we're currently on?
Well, from our research and everybody we talked to, we understood that if we went through a use permit through the DLNR, it would take a considerably longer period of time to build a house. Everything would have to go through state permissions and so forth. And we were looking to retire. We didn't want to take a whole lot of time. And we decided that we also wanted to be treated like the rest of our neighbors in HPP and primarily on Paradise Alakai, without the oversight and the extra burden of going through the DLNR for everything. So we opted to take the boundary amendment course.
So the boundary amendment seemed like the most appropriate avenue for you guys to go.
Yeah, everything we knew about the history of, and the more we learned about the history of the lot and how it became to be in conservation, we realized that it was kind of like a mistake that it was there. I mean, but for the fact that the then owner wasn't able to participate for some reason, the land was left in conservation district. So we thought that we're just trying to rectify that in some way, and then the land can be treated just like everyone else in that area.
Okay. How often do you guys visit the petition area?
We're only 4 miles, so we go down every 2 or 3 days and sit out there and remind ourselves why we're here.
Yeah. And when was the last time you were at the petition area?
We went Sunday.
Okay. How was it?
It was beautiful. We didn't see any whales, but we have been. but it was gorgeous.
Okay. Is the petition area being used for anything right now?
No, it's vacant.
It's vacant. And by vacant, you mean no improvements?
No, there's lots of weeds growing and cane grass and stuff, but nothing else.
Okay. Are you aware of the petition area ever being used for any purpose, agricultural, residential, anything like that?
No, as long as we've had it, and I think even before, there was never anything done there.
Okay. You know, I wanted you to kind of provide some layman kind of testimony of what it's like on the ground, the conditions on the ground at the petition area. You know, we have these technical studies that were included with the final environmental assessment, included with our petition, but I think it's helpful to hear from you about some of these things. So, you know, a moment ago, I just talked about the soils, and there's a couple rating systems that really have these soils listed very poor for agricultural purposes. But can you kind of explain, you know, just in layman's terms, what the soil looks like out there on the property?
When we go out there, we can't actually access the interior of the lot, but it's mostly all volcanic, you know, lumps and crevices and stuff. And I suppose there's, if you dug around deep to around the actual vegetation, there'd be just decomposed organic material. There's no soil per se. I wouldn't call it dirt or soil or anything. It's just mostly like macerated leaves and little piddly things, but it's mostly all volcanic rock and the weeds that grow.
Okay, you mean like exposed rock where you can go and put your hand on the lava?
Yeah, exposed rocky bits. Yeah.
Okay, and then it sounds like it's sort of weeds and plants growing on top of old decomposing dead. I mean, it's not much there.
No.
Okay. And while we're talking about soils and sort of agricultural productivity, if you walk up and down Paradise Alakai Drive, or even, you know, sort of Malka a block or two, is there much agricultural activity going on in this part of Hawaiian Paradise Park?
Well, I mean, people might have fruit trees on their lot, but mostly everything's landscaped. But I'd say no.
Okay. You know, I mentioned earlier that you guys are seeking this boundary amendment so you can build a farm dwelling and implement an agricultural use. Is that correct?
Yes.
Okay, and you guys intend to use this as your full-time personal residence?
Yes.
Okay. What about your neighbors? Are most of your neighbors in that area, are they full-time residents? I mean, based on, you know, your conversations and your time you've spent down there.
I can say that most that we know and are aware of are not full-time residents. Most people live part-time there. Some people we don't even know yet. So
yeah, but not a ton of full-time residents that you're aware of.
No.
Okay. I know you guys are this is sort of the first big major hurdle sort of in the permitting and planning for this project, and I know it's taking some time, but can you kind of give the commissioners just a little more kind of information on your preliminary plans for this dwelling that you guys are proposing?
Well, we want just a simple, modest home, maybe 2 bedrooms, an office, 2 baths. And we're looking forward to lots of outdoor space, you know, lanai space and so forth. We are retired, so we don't want a lot of maintenance. I don't want to clean a big house, and we're just wanting to be comfortable and be able to enjoy that area.
Okay. Now, the petition does mention a pool. Do you guys have any immediate plans on building a pool?
No, it's kind of on our wish list. It's a matter of affordability, but at this point, we're just focused on the house.
But you wanted the commission to be aware that that's something you guys may consider down the road.
Oh yeah, if we can do that, yes, we would probably like to have a pool.
Okay. Now, as you're aware, this is a farm dwelling, and it requires to be used in connection with an agricultural use. And I mentioned earlier, very briefly, that you're planning on an apiary, which is a fancy term for a bee colony.
It is.
Can you just provide a little more information for the commission on what you guys are planning?
Well, I'm a master gardener out of University of Hawaii at Hilo, and that was where I was first exposed to beekeeping. About a year ago, unfortunately, they let go of the apiary that was on site there, but I learned in that process I was sort of fascinated by the bee community and how they structure their hives and everything. So anyway, it was something I never thought I'd be interested in, but I actually did get really interested in it. And when it came down to selecting an agricultural purpose for our lot, we realized we were restrained in a lot of different areas because of the small site, the lack of good soil, a bunch of other stuff, the salt air and wind and all that. So I looked into doing beekeeping, and it turns out that it's actually a possibility. So we're going to go that way, and we're going to create a bee yard on the side of the house with mostly native, salt tolerant plants that bees like for their purposes, and then maybe do an herb garden and some other plants that are allowed to bolt. I also understand that bees travel, so they'll go other places to get their pollen and so forth. But we thought that would be a great idea. So we'll be dedicating that area to the bees. We're going to start out with 2 colonies. We've been told that 2 colonies are good to have together because you can kind of compare the health of one colony to another to see that if everything's going well, that they're both doing good. If something fails, if they get bugs or mites or something like that, you kind of get a head up. But that's what we're looking for.
Okay, and you mentioned that the salt spray and the air down that area presents problems, but you've also discussed with people knowledgeable in apiaries that bees can do well in this environment. Is that correct?
Yeah, it can be tricky. Wind is a factor, salt air, but we thought if we build a fence or some sort of a break or something like that, we'll pay attention to that closely. We've actually been told that it's just a little bit extra work, but we're okay with that.
Okay, and so presumably these bees, the purpose of having the bees is for them to, I understand that people, they become somewhat like pets, like, people with their chickens or even more domesticated pet, but the purpose of the bees is to produce honey and other sort of bee byproducts.
Mm-hmm. Honeycomb, pollen, you can extrapolate the wax and make candles or lip balm and all kinds of stuff. So yeah.
And you guys will then sell those products, is that correct?
Yeah. Hopefully, yeah. Where, either a roadside thing, at the house, or farmer's market if we have enough to pass. So yeah.
Yeah, and you mentioned roadside stands, and that's fairly common in Hawaiian Paradise Park.
Yes. Yeah. In fact, they're around the corner from us. There's a person who sells eggs, and when they've got them available, they have a sign out. So
yeah. And then I think we've discussed before, if you move further Mauka, there's a little more agricultural activities. You get more farther from the coast.
There are signs where people sell plants. I guess they grow plants in pots and then they sell pots. And then we've also seen
Mr. Simon, excuse me if I may, just about how much longer do you think for your first witness?
My first and only witness probably has another 5 to 10 minutes.
Okay.
So we'll
do that, and then if we'll probably take a break.
Okay, understood. Thank you, Chair. Okay, Monica, because this farm don't require you guys to maintain an active agricultural use, what happens if for whatever reason the apiary, the bees aren't happy on the coast, they don't produce well or whatnot, what then?
Well, we'll get another agriculture purpose. We have to get an appropriate purpose that will work for us, obviously, but we hope the bees would work. But there are other things we could do.
Okay, and so you guys are committed to continue
Yes.
with an agricultural use?
Yes.
Okay.
Yes, absolutely.
Okay, let me shift gears a little bit. The amended petition states that, assuming we get a favorable decision from this commission, and then you move to the county and you get your permits from the county, the petition says you guys would anticipate that the dwelling and the ag use to take about 18 to 24 months to build. Does that still sound right to you guys?
Yeah, that's the outside window. We're hoping it'll be quicker, but if we've learned anything in the past few years, it's you never know what's going to happen. So, but yes, 18 to 24 is our outside.
But you're hopeful you may even be able to do it sooner.
Very hopeful we could do it sooner.
Okay. The amended petition also includes a pre-approval letter from your local Hawaii-based federal credit union, and it states that you guys are pre-qualified for a loan sufficient for the amount you guys believe needed to purchase. To develop your project. Is that correct?
Yes,
And in the petition, you guys represent that you have the financial ability to build a project, correct?
yeah,
And
yes.
that's still the case today?
Oh, yes, uh-huh.
As we saw in the picture a moment ago, and you kind of touched on, this is a shoreline parcel, is that correct?
Yes, it is.
Can you kind of describe for the commission what the shoreline parcel, what the shoreline looks like in the area of the petition area?
It's lava, rock, and cliff. It's got some shrubbery growing along the edge, but it's mostly lava rock. That's where when we go now, we go and we sit out there. It's got a cliff about 20, 25 feet down, and it's pretty deep water.
So you can't really access the ocean on this part of the coast?
Okay, well, you what we like to say is you can get into the water, but you probably can't get out.
You probably get in on accident too, huh?
Yeah, on accident. Yeah, it's very rocky, very like I said, deep water, and there's no access. There's no ocean access.
And in our petition, we note that this area, you guys are aware that this area is used by local fishermen and cultural practitioners for gathering purposes. Is that correct?
Yeah. Yes.
And do people use the shoreline area there for anything else?
Well, when we go down, there's other people who sit out there. There's not a whole lot, but there'll be people like, it depends on when you go, watching the sunrise or catching the sunset reflected in the clouds from Kona. But there's always someone else down there looking at the water or fishing or walking. They walk the coast there.
Okay. And Monica, are you aware that, under Hawaii law, shoreline access lateral, both, including lateral along the shoreline, that's protected for both the public and cultural practitioners?
Yes.
Okay. And I know it's in your petition, but can you confirm again for the commission whether this project will in any way interfere with the public's access to or use of that shoreline area?
It will not, no.
Yeah. That's about all I have. Before we end, is there anything else you would like the commission to know?
Well, I do. We do appreciate the commission's consideration of our petition. It has been a long haul, and we are certainly hoping that things go our way. We just want to have the property in our names and in the designation that will allow us to be treated like all the other neighbors in our area, and that's what we're hoping. So.
Okay. Thank you, Monica. Chair, that's all I have for Ms. Berry.
Great, thank you. Let me get a sense first before we take a break. Are there any questions for the witness from the county? Mr. Mukai?
None, Chair.
Mr. Yee from the Office of Planning?
No questions, thank you.
Commissioners? Commissioner Chang? And Commissioner Okuda? Okay, let's do it and then we'll take a break. Commissioner Chang.
Thank you. Thank you so much, Mrs. Berry, for being here. Appreciate your patience. I just wanted to follow up on some questions regarding access. So when you mentioned that when you go down there, occasionally you'll see people maybe fishing. Are they fishing on your property, or is there other properties that they're fishing on?
I can tell you that we have over the years seen people fishing on our property, but as the houses have been developed along those lots and there's no more direct access in front of ours, there are fewer people who actually do fish. Mostly they go to the end of the road or to the 2 county lots that are about a half mile south, and then they go out there. Sometimes they'll walk along to get to a different spot, but the other reason why I know they do fish is because they put in like a PVC pipe pole to hold. So I know that they leave those there and see. So I think that they are, we don't see them as often as we used to, but they do, yes.
And you mentioned there's 2 county at the end of the road. So are those public access or are those?
Yes, those are those 2 county lots. They're not at the end of the road. They're actually in the middle kind of Paradise Alakai, but they are considered county parks in a way. They're not developed at all, but you frequently see cars parked there and people go out. That's where they mainly do. Closer to where our lot is, there is a dead end road, the Paradise Alakai dead ends, and people will park down there and then also traverse over. Tell you the truth, it's probably private property, but it's shipment land, but people will go out to the cliff that way.
Okay. Have you had the opportunity to talk to any of these fishermen that may have been on your property?
We have over the years, not lately, but we have over the years.
Is it your understanding that these fishermen have fished there all the time, or they fish there because your lot's been vacant and it seems to be an easy access to the shoreline?
Gosh, that I don't really know. They're always friendly, and we talk, but they get big fish, they say, and they enjoy the area. It's quiet and peaceful, and sometimes they bring their kids, but I don't know why they picked that area. I imagine it's because it is deep water and there's not a lot of people there, so they probably have a better opportunity to catch something.
Okay. You said you understood that that people have the right of access. So is it your understanding that assuming you are able to build your home there, would you be putting up a fence? Would you continue to permit people to go through your property to fish?
Well, they actually don't go through our property, but even when we develop the property, we rescue greyhounds, we have dogs, so we do need a fenced area. We would not prohibit people from fishing in front of, and I'm saying in front, but I mean ocean side, Mackay side of if they happen to go down there, the lot will be fenced. We can't not do that, but they're welcome to come in the public area there and on our oceanside lot.
One final question. Do you know whether the certified shoreline is at the end of your lot that's, it falls into the cliff, or is the certified shoreline further malka so that there is an access, a lateral access? My
limited experience with that is that there is a buffer, that state land, I think it's 20 feet, maybe 30, that is considered the certified shoreline. I'm not real sure, but then back from that 20-30 feet, then there's another 40 feet that I think the county requires as to be open as well. So it's a good portion.
Okay, that's really helpful. It wasn't clear in my mind when I looked at the map. So your property is not adjacent to, the cliff that goes into the ocean. There's at least a 20-40 feet buffer from the cliff to, okay.
Yes,
very
yes.
good. And you would not prohibit anybody from accessing that public area. Very good.
No, not at all. Yeah.
Okay. Thank you very much. I appreciate your
Thank
testimony.
you very much. I appreciate it.
Thank you, Commissioner Chang. Commissioner Okuda? And then we'll take a break.
Okay, Chair, since we've been going about an hour, do you want to take a break now?
How long do you have, Commissioner Okuda?
Maybe 10 minutes.
Okay, then let's take a break. It's 9:59. Well, we will go into recess and reconvene at 10:10.
I sent you an email on a matter. So thank you.
Thanks, Brian. I see your email.
Anyway, hi, commissioners. How are you guys?
In 3 days, it will have been a full year since I was last on an airplane.
Oh my goodness. Well, unfortunately, I made 2 trips. Last March, or right at the end of February, I went to the mainland on a full plane and came back almost at the end of March. Okay.
We can get back on, including our witness. I believe we have all commissioners. Yeah. Okay. It's 10:10 a.m. We're back on the record and we're continuing with the cross-examination of the witness, Ms. Monica Berry. Questions from Commissioner Gary Okuda. Mr. Okuda, please proceed.
Thank you very much, Mr. Chair. Good morning, Ms. Berry. Thank you very much for taking time to testify today.
My pleasure. Good morning to you too.
Can I just ask a few follow-up questions? One is your attorney, Mr. Simon, mentioned that you were with the courts out in San Diego?
I was a staff attorney for the San Diego County Superior Court, yes.
Okay. And can I ask about how many years have you been an attorney?
Since 1996.
Okay. Okay. Before you and your husband purchased the property, you gave us some testimony about some due diligence, or your attorney was describing some due diligence that had taken place. So before you purchased the property, you understood that the property was in the conservation district. Was that correct?
We did. As I mentioned before, we learned that through escrow proceedings. It wasn't initially known that it was conservation land. So it was through that process that we learned it was in conservation land. So then we went into full gear, like, what does that mean? What's conservation land? What's this? And then, of course, that's different than anything we were used to in California. So we did lots of research and talked to people. In 2007, which seems like an eternity from now, things were different. And we opted to start the process once we moved over as full-time residents. So that's what we did.
Okay, frankly speaking, I went to law school at UC Davis and left in 1981, so I have no recollection of the law in California, so please don't ask me about that. But if I can ask you about your due diligence process, when you were purchasing the property, were you represented by a Hawaii real estate agent?
We were, yes.
And what was your intention, or your husband's intention in purchasing the property? Was it to engage in any type of business activity on the site, or was it simply for retirement purposes?
We only wanted retirement. As I kind of alluded to, we were at that point looking to quit working. And we made a full-on pledge and plan to sock away as much money as we could so that we could retire as soon as we could. So we had and continue to have no interest in doing anything business-wise. We just want to relax and retire.
Yeah, I understand that. You mentioned that you wanted to be treated just like your neighbors. If I can ask about that, with whatever distance to the left or right of your property, are any of your neighbors, based on your personal observation, using their properties for agricultural activities, or does it appear to be, frankly speaking, like a single family residential subdivision?
for all intents and purposes, and as you say, speaking frankly, it's a single family residential subdivision. Particularly down in our area because of the half-acre parcels. In the area of HPP where they have the single acre parcels, there may be more actual agriculture purpose, but you don't see rows of planting or you don't see any of that sort of stuff. It's a very casual application, in my opinion, of the agriculture purpose use. But that's basically how the neighborhood is set out.
Now, you also mentioned or testified about doing your intended development, and you gave us reasons why you did not want to go through a conservation district use permit with the Department of Land and Natural Resources. Without getting too technical here, can you tell me in plain English, if you can, what you saw as the impediment or problem with going through the permitting process through the Department of Land and Natural Resources?
I can tell you anecdotally, over the years, once we bought the land, and it became a great distraction for us to plan like what the house would look like, what we would do when we got there and so forth. So we revisited regularly, probably once a year at least. And when we would come, we would attempt to talk to professionals, you know, home drafters, architects, you know, planning people. And I kid you not, as soon as we mentioned, well, we're going to, you know, eventually plan on building after we retire, but we have to go through some permitting process because it's conservation land. Everything stopped. Nobody talked to us. We're on conservation land. They literally would say, oh, well, come back to me when you have this squared away, because they, you know, everything takes longer. You have a little bit more scrutiny, a little bit more oversight. There's a little more burden in everything that you do. And in fact, at one point early on in our process, I called the DLNR and they told me the words to stand out in my brain. You cannot cut a blade of grass on your lot without a permit from the DLNR. And I thought, what? So we thought we don't want that. We understand what it meant to be in conservation district, but we didn't. And based on the 1977 order, we realized that that parcel wasn't really appropriately in conservation land. So we didn't want to have the always looking over our shoulder or landscaping purposes for any little thing where we were going to worry about having a permit or having permission. So we wanted to be on par and in parity with our neighbors so that we knew how we could use our land. We knew without worry that we would be overstepping or something. So that's why we really wanted to go with the boundary amendment.
Now, I'm not asking the next question for any communications you or your husband had with your attorneys, because as an attorney, you understand that
yes.
privilege, and even though we are quasi-judicial, we cannot invade that privilege. So without asking you to divulge anything your attorneys have ever told you, has anyone ever told you that it would be impossible for you to get a conservation district use permit to build a house, this retirement house as you planned, from the DLNR, the Department of Land and Natural Resources? Anyone give you advice saying it's just not going to be possible at all to get such an approval?
Quite honestly, it was to the opposite. We actually had people say, well, why don't you just go through this permitting process, the conservation district permitting process. That's what everyone else does. But we were looking at the length of time that it would probably take, and the fact that we didn't want to use that time. We're we're seniors now and we want to kind of expedite that whole process. So it worried us to have to rely on that. We actually, I can't recall anyone ever telling us that it was impossible.
Okay. Two final questions. One is, did you ever form an opinion that the reality in Hawaii is, frankly, no government agency is really enforcing restrictions on agricultural land? That's why, for example, you see your neighbors with single-family residences and no agricultural activity taking on. That once you get an agricultural designation, hey, nobody's going to really enforce the rules. I mean, did you form at any time that impression or opinion?
I suppose one could say there's very little enforcement, but considering my background, there's always the possibility of enforcement. So that's always a concern of mine. I'm a structured person and I like to live within the structure. So I understand that, yeah, there may not be a great deal of enforcement, but there's always possibility. The other thing I'd like to say in that regard is that I also find fascinating the conundrum between the county and the state, right? Because the county considers that lot agriculture, but the state considers it conservation. And there is a tension, right, between public, use and custom and what it's evolved into. Because originally, like Derek was saying, in 1957, there was none of that. So it's evolved, right? So you never know.
Yeah, and this might not be really the place to go into a lot of it, but I think one of the reasons why the legislature passed the land use law was because of, it might be this particular subdivision, that there was these people named, I believe it was Hirotoshi Yamamoto and a bunch of other people, Manoa Finance Company, that developed these subdivisions, and the policymakers decided there had to be regulation, but that's maybe neither here nor there. One final point, whatever we do here, you probably understand that we are quasi-judicial, meaning when you talk about we're structured people, we are required by the structure to take the laws that the legislature has passed and look at the evidence. The strict rules of evidence don't apply, but there are rules of evidence that apply here. And we basically have to make what amounts to a judicial determination or quasi-judicial determination. So we, as far as structure goes, we are constrained about what we can do and we cannot do. But anyway, Ms. Barry, thank you very much for participating in your testimony. Very much appreciated. Thank you, Mr. Chair. No further questions.
Thank you.
Thank you very much, Commissioner Okuda. Commissioners, any other questions for the witness? If not, very briefly, Ms. Berry, did you ever consider doing this pro se?
No.
Why not?
Working for as long as I did for almost 19 years with the court, I realized the old adage that, it's a fool who uses himself as his own attorney. And I understand that there's a significant amount of law that I don't understand coming from California that's here in Hawaii, especially land use topics and so forth. So no, we never did.
Okay, thank you very much. That was my only question for you.
Okay.
Anything else, commissioners? If not, thank you very much, Mr. Simon. You can continue on your presentation.
Can I ask Ms. Berry just a couple follow-up questions, Chair?
Of course.
Okay, Monica, a couple quick points, and I did a poor job of this on my direct view, so let me apologize for that. Let's talk about access real quick. So Commissioner Chang asked you some questions about access.
Yes.
Are you guys able to access the shoreline area right now through your lot?
Not through the lot, but around the lot, yes.
So how do you guys get to the shoreline?
We go to the end of the road, to the end of Paradise Alakai, and we traverse over that property.
Which may or may not be trespassing.
Yeah.
Okay, but there's no public access through your lot. There's not even private access through your lot. At the moment.
It actually physically, you cannot walk through it. I mean, it's debris and it's overgrown and yeah, you can't.
Okay, and thank you. And I also did a poor job of kind of describing what this area looks like that the public sometimes uses to fish and to gather and for other cultural purposes. I think it came out, what essentially we have is sort of a lava shelf, is that right?
Yes, a lava shelf, yes.
And you guys haven't certified your shoreline, is that correct? It's an
Not
empty
yet.
lot. It's an empty lot.
It's an empty lot.
But you can kind of tell where the vegetation stops and it's bare lava.
Oh,
is that
yeah.
correct?
Yeah.
And
it's
how wide is that area?
I would say 20, 25 feet or more. Yeah.
Okay,
It's very distinct.
From okay, yeah, and the public has free use of that whole area, is that correct?
Oh, yeah. Yes.
And you guys will in no way interfere with the public's use of that area?
No. Mm-mm.
Okay, and not access to that area either, right?
Pardon?
You will not interfere with their access to that area either?
Oh, no,
correct?
not at all. No. In fact, we kind of enjoy that.
Okay. Commissioner Kudo asked you some questions about ag activity in the area and your intentions and stuff. And you mentioned that you didn't buy the petition area with the idea of starting a brand new business. Is that correct?
Correct. Yeah.
Okay. But you guys do intend on conducting business using your agricultural activity to conduct business. Is that correct?
Absolutely. Yeah. I understand that. I should distinguish that in saying that because it's an agriculture purpose, we understand that we've had to since commit to some sort of business activity in order to sell the honey and the bee products that we get from our bee colonies.
Okay, and you understand that under the commission's rules and also its statute under Chapter 205 that you are, if the commission grants you the requested boundary amendment, you're bound by these commitments and representations that you're making to the commission, both in our filings as well as in your testimony today. Is that correct?
Yeah, absolutely. Yes.
And you guys remain firmly committed to pursuing this agricultural activity. Is that correct?
Yeah. Yes.
Okay. And one kind of on a related note, we talked, you kind of mentioned how you kind of like to stay within the rules and work with what is provided.
Yeah.
And so there was a talk about a lack of enforcement in the area. And I think what your point is that notwithstanding the lack of perhaps active enforcement, that won't in any way affect how you guys conduct your own use of the parcel. Is that correct?
Correct. I should clarify that in saying that we understand that on some level we will be treated differently than our neighbors. The part that we want to be on parity with is we want to go through the county. We want to go through try to avoid DLNR in the building process, but we do understand that we are promising and we are committing to doing an agriculture purpose. For the purpose of this process, we do know that we will be treated differently that way.
Okay. I don't have anything further, Chair. Thank you very much.
Okay. Thank you, Ms. Berry. I'm going to put you back into being an attendee, and then Mr. Simon can continue with his presentation.
Thank you.
Chair, that includes the chief part of my presentation. I'd like to reserve time to respond to anything from the other parties, as well as provide some closing statements for the commission.
You certainly can. Okay. With that, I'm going to call Hawaii County.
Yes, thank you, Chair. For the record, this is John Mukai, Deputy Corporation Counsel, and just for clarification of something regarding the Barry property, I'd like to have Hawaii County Planning Director Zendo Kern address an issue.
Okay.
Thank you.
Mr. Kern, I'm going to swear you in. Do you swear affirm that? I think the last time I saw you, you swore me in, so it's fair play. Do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay, please proceed.
Thank you, Mr. Chair. Yeah, so Zendo Kern, Planning Director here. I actually grew up in this area, and I actually grew up fishing along this coast as well as diving along this coast. Just wanted to make a slight point of clarification. Their TMK, this property actually does abut the coast, actually does abut the water. Where the certified shoreline survey will end up being might be at the top of Polly or the top of the cliff, but I just wanted to make sure that that was clear. We will have a 40-foot shoreline setback in that area, and our SMA rules will not allow any fencing up in there, so the lateral movement along the coast would remain open. I'm sure the petitioner is fully aware of that, but just wanted to clarify that this property does. It's technically oceanfront.
Okay.
And happy to answer any other questions, but more of a clarification.
Was that Mr. Mukai? Was that it from Mr. Kern?
Yes, Mr.
Okay.
Chair.
Okay, just make Mr. Kern available for questioning. Mr. Simon, any follow-up?
Any follow-up for Director Kern?
Correct.
Not at this time.
Okay. OP,
No questions. Thank you.
commissioners, Commissioner Okuda, followed by Commissioner Chang.
Thank you very much, Mr. Chair. Thank you, Mr. Kern. Can I ask you this question, Mr. Kern? I'll tell you what my concern is, and I don't know whether you can address it. The concern is that when applicants, and I'm not indicating a decision one way or the other regarding this Barry petition, but sometimes I get the feeling that people will tell us what we want to hear to get a petition granted or a permit issued. And then, we know from the case law that once there's substantial commencement of the use of the property, the Land Use Commission loses the ability to simply revert the property as a result of non-compliance. And we don't see the county enforcing, the requirements, for example, that actual agriculture, commercial agriculture takes place on the land. I mean, do you have any comment about that? Because, I get the feeling that if we're not going to see county enforcement of some of these requirements, it's almost like people are forcing the Land Use Commission to have to take a really strict view of applications.
Well, obviously, you know this probably better than I do. It's a very complicated subject matter, and I'm sure some folks do say what they want to hear. In this case, I'm not saying that. I feel like they have their intentions set to do what they're going to do. I think the land use conversation in general, though, around agriculture use and the state land use ag on the Big Island is complicated, especially for an area like Paradise Park, where it's much more of a rural type setting, and it'd probably be actually more effective to be rural as far as state land use goes, and actually focusing the agriculture components into the areas that, like on the Hamakua coast, and areas that we actually have higher and greater potential there. We're challenged as a county as far as bandwidth goes. I mean, just even keeping up with processing permits and whatnot is something that we're, working on streamlining and working through. So greater enforcement across the board is challenge. It's something that we're discussing and bringing up on the general land use policies and how we can actually create some more cohesion in that regard, because it's challenged. We don't have any immediate plans for that, as we're still kind of working through general plan, intergov, and taking on this position with the new administration. We're buried with some of these other issues, and then this would be probably phase 2 of my conversation with the team.
Okay. Thank you very much, Planning Director. Appreciate your answer. Thank you, Mr. Chair.
Thank you, Mr. Okuda. Commissioner Chang.
Yes, thank you, Mr. Kern. I appreciate the clarification. So I want to talk about the shoreline. So your testimony is that the Barry's TMK actually goes all the way up to the edge of the cliff. Is that correct?
Correct.
Okay, but the county has a 40-foot setback requirement. Is that correct?
That's correct, yeah. In certain cases where it was a 20-foot, depending on the depth of the lot, but Act 16 that was passed last year now basically creates a 40-foot shoreline setback in all cases.
Okay,
So that would be from the certified shoreline survey.
And are you aware whether this property has a certified shoreline?
I'm not.
Okay, and so notwithstanding the testimony about the vegetation, in this case, the TMK shows that the property goes to the edge of the cliff and the county has a 40-foot setback. And within that setback, they cannot build any structures?
That's correct. There's no structures, no fencing. The only way that they'd be able to do that is to come through with a shoreline setback variance, which would require an environmental assessment, and it would be a discretionary application that'd be approved by the Planning Commission.
Okay, but with the shoreline setback, is there a implied public easement that they can cross over?
That's my understanding. Mr. McKay could maybe expand on that, but yeah, as far as that lateral movement along the coast, it's pretty much open for the public to traverse, and that whole area is pretty much maintained that way. No one's tried to block it, so fishermen can walk up and down the coast, people picking up pihi, etc. I mean, I've walked that entire coast many a times, and that lateral movement is basically never questioned.
Yes, so currently by practice, it's unobstructed lateral movement. That's been your experience of the properties along the shore. However, if they did come in, and I'm not saying that they will, but if any landowner came in requesting a permit to build a fence, you would still go through the process of determining whether a fence is appropriate or not.
Yeah, there would be a process. We'd have to go through the process, the application, the review, and how that, whether conflicted or complied with, SMA requirements. They'd have to do an EA, they'd have to get a FONSI on that. And from our standpoint, even if it kind of worked for the most part, we would not allow a restriction. We would maintain lateral access along the coast. That would be our recommendation. Now, the planning department doesn't get the final say. We're a recommending body for that. So it'd be the commission that would have the final say on that. In my experience with the commissions, shoreline access and movement is something that's really looked at with great detail and honored.
Okay. So I guess that's my question to you, to ensure, and I believe Mrs. Berry is extremely genuine when she says she has no intention, but to ensure that access continues to run with this land, public access, would you find it appropriate for LUC to include a condition in the approval that there be at least a required public access fronting the property? Was it 40 feet or 20 feet?
I don't think that that's necessary. I think with the practices that we have and all the conditions and requirements that we have, I don't feel that would be necessary.
Okay. Are you aware of any of the other properties having such a condition on their properties?
I'm not, but I wouldn't say that I'm extremely knowledgeable in that department either.
Okay. Thank you very much. I appreciate your testimony.
My pleasure.
Commissioner Cabral.
Yeah, thank you, Chair. I wanted to kind of comment and actually support the comments that Petitioner Barry gave and Director Kern gave. In one of my former lives, I used to be a fisherman, and I fished along that coastline, Alua fishing, of course, because we went for the big game, of course. And that area, because I'm trying to draw that picture, this is not one of these beautiful little beaches you walk out to. And in some areas, the lava is so horrible that, even walking along that coastline, you're going to need that 40 feet because sometimes there's drop-offs and there's big pukas in it. And it is not this is not where you take the children to go play in the sand location. And this particular lot, parcel 59, is very close to the end of the entire Paradise Park subdivision. And like Mrs. Berry said, about 2 more lots down is the end of the roadway. And I am familiar, people do stop there, they park there, and they go into the WH Shipman property a lot, and they'll go along that coastline for most of that same, I think I've been there probably trespassing, and that same kind of terrain, and it just drops off, and the surf, when it's high surf, it's just pounding up against you, you know, so it.
Commissioner Cabral, if I may, do you have a question for Mr. Kern?
Well, yeah, but I wanted to also support that, Mr. Kern's suggestion to Commissioner Chang, that we probably don't want to have to require that the 40-foot setback be enforced as part of our LUC, because the people who do use that and go along there, trust me, if someone blocks them, the county will hear about it. It will not be tolerated, because a lot of people do terrain across there for fishing and camping and what have you. So I think we can let the county and their enforcement, and the county it's very responsive to complaints. It doesn't go out looking for problems, but if somebody complains, they're pretty good at coming out for it. So this is not a beach scene that I think some people are picturing this pretty beach that we need to protect. That's not it. So I'd encourage that we move along. Thank you.
Thank you, Commissioner Cabral. Commissioner Ohigashi.
Yeah. So Nancy's comments made me realize that, or seem to get the picture that it's not rubber slipper friendly over there. But besides that, I have a question for Mr. Kern. Mr. Kern, there's testimony from the petitioner saying that they have certain types of stands to sell agricultural products. Is that area governed by this? Are those type of activities governed by the special use permit, or is that area do what you like area without the permits?
Well, I wouldn't say it's a totally do what you like area, but they're not governed by special permits. We have provisions in the code that if you're on ag land, you can have your little fruit stand out in front. So it's not like a store or anything. It's a small fruit stand, usually on the honor system, where here's put out 2 dozen avocados and some papayas and whatnot, and somebody leaves a couple bucks and grabs them, or kids kind of doing their own little fruit stand. And usually that's from small scale, kind of personal little orchards or got extra fruit on their property.
And about how much of that subdivision, the actual lots and the buildings they're on, sort of grandfathered in? Because it was mentioned by Mr. Simon that the subdivision occurred even before 205A or 205 was indicated. I'm just curious, is there a percentage that you can give me about?
To my knowledge, and I could be not 100% accurate here, but pretty much the entirety of Hawaiian Paradise Park subdivision was pre-205. Again, there could be a couple on the fringe that maybe had been subdivided, but I don't even think that would be the case. I don't think anything's really happened in their sense.
And so what I was just curious is will the petitioners be subject to regulations that were implemented, will not be able to avail themselves of any of the grandfathered in rights that the other residents have?
Unless you folks make some other decision, we would treat them the same as everybody else as far as zoning goes.
So they would have some grandfather type of rights because your zoning is agricultural.
The zoning is ag, yes. Yeah, I'd have to double check with our corp counsel, but I don't see any reason that we would treat them any different based on this petition. Because it basically make it conforming with the surrounding areas, right?
Yeah, I was just curious. Thank you.
Yeah. Thank you.
Thank you, Commissioner Ohigashi. Any other questions, commissioners? Thank you very much, Mr. Director Kern, for your clarification on the TMK boundary. Can I ask you one very quick question following up on Commissioner Okuda's questions, which is, if you know, can you describe at all at what points in, if somebody's coming in for a permit, will the planning staff on Hawaii County check against the LUC records for any conditions that might exist on the property?
Pretty much immediately. So the permit would be generated at the building department. It would come to the planning department. We'd immediately see that's an SMA, and we'd follow up anytime there's especially a shoreline area. We'd look through the records, see if there's anything that was from the LUC, any SMA, anything else from SHPD. In this case, there would be an SMA assessment, and it could be an SMA major depending on what they do, because Act 16 changed those exemptions as well. So immediately we would get that. We would look at all of those. All of those issues would have to be addressed prior to it moving forward to getting the building permit. So we are very, very detailed, especially with the shoreline properties like this.
That's very helpful, Director Kern. Thank you. I notice Commissioner Okuda has a follow-up question.
Yes, thank you very much, Mr. Chair. Director Kern, following up to the chairperson's question, will your permitting people look to determine whether or not there is business or commercial agricultural activity going on the property? Your predecessor in a prior administration, I believe, a representative when the short-term vacation rental issue came up before the commission, said that the department would not check whether or not there is bona fide agricultural activity taking place before any type of permit would be issued. Is that still the policy of the county, that there's going to be no check of whether or not there's bona fide agricultural activity? And when I use the term bona fide agricultural activity, I'm using that term consistent with the Land Use Commission declaratory ruling in docket DR 83-8, which states that the agricultural activity cannot be simply for personal or household use. It has to be for commercial purposes. Is that issue going to be checked or not checked when the permit application comes in?
Mr. Kern, please respond. But I also just want, since you're not in the same physical location, I just want to also flag Mr. Mukai can jump in.
Yeah,
he wants to.
Yeah, no, to be quite frank, that policy hasn't changed yet. We've been in this position for maybe about 3 months, and we've been focused on a lot of other policies as far as process and flow goes right now that we've been dealing with. So as of right now, it hasn't. And again, it's something that we're going to be having a conversation about. We do have them fill out the document that you're aware of that was brought up during that previous LUC hearing. But as of right now, it'd be the same that was expressed before.
Okay, thank you very much.
Okay.
You're welcome.
Anything further for Director Kern, commissioners? If not, Mr. Mukai, thank you very much, Director, and Mr. Mukai, you may continue.
Thank you.
Yeah, nothing further, Chair.
Okay. Any other general questions from the commissioners for the county? If not, we will go to the Office of Planning.
Thank you. First, I have to apologize. The Office of Planning submitted its written testimony, and you will notice on the caption, it references an Exhibit 1, which was intended to be attached to our testimony. During the hearing, I'm informed that unfortunately we did not include Exhibit 1 in our filing. It consisted of comments from DLNR to the Office of Planning, and is referenced in our testimony that was filed. I was wondering if I could beg the indulgence of both the commission and the parties. I only sent it to the parties during the hearing, so admittedly they've had, frankly, very little time to review it. But was wondering if we could amend our exhibit to amend our written testimony to include those exhibits to make it complete.
Okay, thank you for that disclosure, Mr. Yi. Mr. Ordenker or Mr. Hakoda, has that been provided at least via email to the commissioners?
Mr. Chair, this is Riley. The email was received. I'll forward it to the commissioners once I'm able to get it on my phone.
Okay, thank you. Are there any objections to the amendment of the exhibit, amendment of the testimony to include the exhibit? Petitioner?
Chair, just speaking purely as a record, for purposes of record, no, petitioners have no objection to the inclusion of the letter as part of Office of Planning's testimony in support of the petition.
Okay, Mr. Mukai?
No, no objection.
Commissioners? You know, we let you go off on your own for a few years, Brian. You get sloppy. It's good,
I
good you
appreciate it.
came back in front of us.
Chair,
Commissioner Wong.
yeah, for my indulgence, can I get, like, once we receive it, can I have 5 minutes to review it so I can complete the record
Yeah.
for my indulgence?
I think that's appropriate. So, you know, given the time we're at, we're going to go about 10 more minutes and take a break. What I'd like to do. Oh, Mr. Ordenker? You're muted.
Riley, hang on. They're going to send it right now, Chair.
Sorry. Did Mr. Ordenker wish to say something?
No, I'm good.
Okay.
Thank you.
What I was going to suggest, but feel free to interrupt Mr. Ordenker, was that let's do the formal acceptance of the exhibit after our next break when commissioners have had a chance to look on it. But can you proceed with your presentation before that, Mr. Yi?
Yes, I think for Mr. Funakoshi's benefit, given that I think we will not need, the alternative was for Mr. Funakoshi to frankly talk about it in greater depth during his testimony if the commission was not inclined to so accept. But given that, I think if I could just let Mr. Funakoshi know, it will not be necessary to go into the level of detail regarding the exhibit.
Okay.
Intended. So with that, we have just one witness. I believe we can waive our opening statements, but we'll obviously request a few minutes to provide final argument at some point before
Sure thing.
those decisions.
Okay, but you're going to call Mr. Funakoshi?
Yes.
Okay. Do you swear from testimony you're about to give us the truth?
I do.
Okay, please proceed.
Thank you. Mr. Funakoshi, could you give your name and title, and then if you could just proceed summarizing the Office of Planning's testimony in this manner.
Hi, thank you and good morning, Chair and Commissioners. Rodney Funakoshi, I'm with the State of Hawaii Office of Planning. I'm the Land Use Division's Administrator.
And what is the Office of Planning's testimony in this case?
Yes, this will be fairly brief. The Office of Planning recommends approval subject to conditions. And so we have basically two conditions, and these were already represented and committed to by the petitioner. And so I'm going to read them into the record. Petitioner has committed to a condition, first of all, that construction will refrain from activities that disturb or remove the woody vegetation taller than 15 feet between June 1st and September 15, when the Hawaiian hoary bats may be sensitive to disturbance. And then secondly, all exterior lighting will be shielded from shining upward in conformance with Hawaii County Code 14-50, its sequence, to minimize the potential for disorientation of seabirds. So the DLNR Division of Forestry and Wildlife letter that you should be getting or looking at during the break basically covers more than that, but we thought that these two conditions are fine in addressing the DLNR memo to the Office of Planning. And then beyond that, the petitioner's final EA has addressed archaeological survey and kapa'akai analysis. And there are no other issues of concern relative to state resources. And so we recommend that the petition be approved with the conditions as represented by the petitioner that we feel will address the concerns raised. The boundary amendment does not conflict with HRS Chapter 205 and generally meets the Commission's decision-making criteria in 205 and Administrative Rules Chapter 15-15. So that concludes my testimony.
Thank you. I have no other questions. He's available for cross-examination and further questions.
Thank you very much, Mr. Yee. Mr. Simon, questions for the witness.
Good morning, Mr. Funakoshi, and thank you very much. And I just want to, on behalf of petitioners, just want to thank you, Director Evans, for the office's support on this petition.
You're welcome.
Mr. Mukai.
No questions, Chair.
Commissioners. Commissioner Okuda?
Thank you very much, Mr. Chair. Mr. Yee or Mr. Funakoshi can respond to this question. In the other prior docket, the Office of Planning brought to our attention a ruling that the Land Use Commission made in docket DR 83-8. And it's the ruling is rather short, so I would like to just read it very quickly and ask you whether or not it's the Office of Planning's position that that ruling is still in effect and is good law. And let me read it from the last page of the DR order. And I quote, "Based on the above, the Land Use Commission rules that a single family dwelling can be defined as a farm dwelling only if the dwelling is used in connection with a farm where agricultural activity provides income to the family occupying the dwelling, and that a single family dwelling which use is accessory to an agricultural activity for personal consumption and use only is not permissible within the land use agricultural district. This ruling is applicable to all lands located within the state land use agricultural district." Is that a correct statement of law, number one? And number two, if it's a correct statement of law, is it the Office of Planning's position that that statement of law binds the Land Use Commission as of today?
Mr. Funakoshi, would you like to answer that, or would you like me to answer that?
Yeah, I would say yes and yes.
Thank you. No further questions.
That's the shortest answer Mr. Funakoshi's ever given to the Land Use Commission. I'm taken aback. Any other questions, commissioners? Seeing none, Mr. Yee, that's it, right?
I have no further question. Thank you.
Okay, it's 10:57. What I'm going to suggest is that we take a break, and then I'll allow for closing arguments by each of the parties, final questions from the commissioners, and then we can go into deliberation. Does that sound acceptable to the parties, Mr. Simon?
Yes, thank you, Chair.
Mr. Mukai?
Yes, that's fine, Chair.
And Mr. Yee, you're good with that?
Yes, thank you, Chair.
Okay, it's 10:57. Let's reconvene at 11:07 a.m. Okay, it's 11:07 a.m. We're Mr. Axon, Commissioner Axon, are you there? Commissioner Cabral? Okay. Commissioner Cabral, if you could face the. Thank you. We're back on the record, and just to clarify, we still, before we go into final arguments, commissioners, I'm assuming you've had the chance to review your email and C, the attachment to the Office of Planning testimony, the letter from the Division of Forestry and Wildlife, which was inadvertently admitted. Are there any objections to entering that in as a corrected exhibit? Seeing none and hearing no objections from any of the parties or the commissioners, Mr. Yee, that's been corrected.
Thank you.
With that, we'll proceed with Mr. Simon to do closing argument with questions from the commissioners, followed by Mr. Mukai, if any, followed by Mr. Yee, if any, following which we don't do deliberation today, but we'll close the evidentiary portion of the proceedings and I'll give instructions to the parties. Mr. Simon.
Thank you, Chair. In keeping with today's theme, I'll try to keep this brief, but I would like to begin first by thanking the commission. I know you guys all work on a volunteer basis, and so we petitioners, the Berries and myself really appreciate all the time you spend to help process these petitions. Also want to thank staff, especially Scott Derrickson and Riley Hakoda and Executive Officer Orrin Denker for all their help along the way. You know, based on the extensive record before the commission, including the very firm representations made by the petitioners, the final EA and the FONSI, we asked that the commission grant the amended petition to reclassify the petition area from the conservation district to the agricultural district by finding by a clear preponderance of the evidence that the proposed boundary amendment meets the standard for the agricultural district under Hawaii Administrative Rule 15.15.19, is reasonable, is not violative of HRS Section 205-2, and is consistent with the policies and criteria established by HRS 205-16, 205-17, and 205A-2. Thank you very much.
Thank you, Mr. Simon, and thank you for the brevity. Commissioners, are there any questions? Commissioner Wong?
Thank you, Chair. Mr. Simon, you know, I read OP's exhibit during our break, and following Mr. Funakoshi's statements, do you agree with those two conditions that is in the exhibit?
I haven't had well, let me make sure. I'm unmuted. Okay, sorry about that. I haven't had a chance to read that super thoroughly, but my understanding is that the conditions they're actually requesting are not just in the exhibit, they're actually in the testimony that they filed yesterday. And those relate to shielding lighting, which is actually a requirement under the Hawaii County Code, and also refraining from, falling trees of 15 feet or taller, which the petitioners have already committed to doing both in the petition as well as in the final EA. And so we have no objection to those two commissions as expressed in the Office of Planning's testimony.
Thank you. Thank you, Chair.
Thank you, Commissioner Okuda.
Thank you very much, Mr. Chair. Mr. Simon, maybe you can help me in this little conflict I have in my mind. I find your client, Mrs. Barry, to be a very credible person. And if that was the only thing, then that would make, I think, the decision-making a lot easier. But the other stuff, and help me out with this, that is kind of weighing in my mind is, number one, the fact that the stated intentions of the Barrys were to retire. And, and there's nothing in, for example, your final EA where there was any discussion of commercial agricultural activity. So that seems to conflict with representation that there would be commercial agricultural activity. And I think the overriding concern I have, and maybe you can help address or answer this, is that we seem to see across the state, people giving a wink and nod to the requirements, which were the requirement that in an agriculturally districted property, you have to have commercial agricultural activity. In other words, agriculture simply for home or personal use is not sufficient. But we have people representing, don't worry, we're going to comply with the law. And we start seeing, just residential use without agriculture. And that seems to take away from the protections that I thought we were supposed to perform in the Land Use Commission to protect agricultural land for bona fide agricultural use. I mean, how do I resolve these conflicting points? How can you help me with that?
Thank you, Commissioner. You know, I understand your concerns, and I would say in part, I don't know if I can resolve all your concerns because I can only speak on behalf of the petitioners, Monica and Kevin Berry. I will say they've made very firm representations to this commission, and they've been advised repeatedly and are well aware that they'll be held to those representations. I understand that there appears to be some disconnect between what the law says and the application and the reality on the ground, especially in places like the Big Island, where you have thousands and thousands of acres like Hawaiian Paradise Park, where agricultural and sort of rural uses begin to blend. But for the purposes of decision making on the docket before you, on the petition before you, I agree that Ms. Berry is extremely credible and she's sincere and she's very honest. She's a licensed attorney. You know, she understands representations and legal ramifications for failing to follow through with her representation. So I can't offer you much beyond the petitioners because I can't speak for them beyond what they've said for themselves. But I do think you have a sufficient basis to act on the current petition and approve it based on the representation of the petitioners that they will satisfy the requirements of the farm zoning under both Chapter 205 and the county zoning requirements.
Well, Mr. Simon, can I also ask an additional question? If it's possible to have their development approved through the Department of Land and Natural Resources under a conservation district use permit, why not just go through that, that route? Because then if for some reason, commercial beekeeping or other commercial agricultural activities can't take place, then, there's not going to be a potential violation there.
Well, I'm mindful of not to disclose, privileged conversations, but I think Monica Berry summed up her reasoning, her and Kevin's reasoning for going this route. I think it's good reasoning. I think they had a justifiable basis to go down this route. Even in past hearings, Chair Shore, commended us for not going the conservation district use permit route. And I think that there are critics of the conservation district use permit and the idea that single family dwellings belong on conservation land. So I think there's tension regardless of which direction they head in. And I think that the direction that they have chosen is appropriate and able for, ready for approval for the commission.
Okay, thank you very much for that explanation, Mr. Simon.
Thank you, Commissioner Okuda.
Commissioners, any further questions for Commissioner Cabral?
This again, not necessarily a statement, but more of a question, more of a statement, particularly to Planning Director Kern, who mentioned this is a huge problem. And I can absolutely appreciate my fellow Commissioner Okuda's conflict here, because it not only are probably most of the houses around them residential, they're probably short-term vacation rentals, and how many of those are even paying the proper taxes, God only knows. It's another huge problem over here. But and the land is absolutely not suitable for anything agriculture. I was impressed that they figured out beekeeping, because I'm thinking, what can you even do on that? I mean, find a lava tube and grow mushrooms or something. So it's a monster problem, and I'm going to defend the Berry's right or ability to make use of their land in the most appropriate manner possible on a half acre of land in that oceanfront setting. That I would hate to see that a mistake of the past be something to restrict them from their ability to have private use of their land in a manner to which other neighbors have. And it's something I would absolutely want to encourage the new administration in our county to clean up. As a realtor, how many of my agents have taken our clients down there and said, oh yeah, just sign this paper that it's going to be a farm dwelling, and on a half acre or 1 acre of lava land, there's not a lot you're going to do. So I really want to defend the Berries for their attempt and their decision to try and do.
Oh, you muted yourself. It wasn't me, I promise. You're still muted, Commissioner.
Okay, sorry. No, I did it. Yes, sorry. Anyway, Commissioner Okuda, I agree with you. It's a horrible conflict, but I'm not quite sure if that Barry should be the only one on the lynching pad there, you know, so there's a lot of people that, and I would say our government leaders need to clean this up in a really big way. Thank you.
Okay. Further questions for Mr. Simon? Mr. Simon, I'm going to ask you whether you've advised your client, Mrs. Berry, that the one product for trademark reasons she probably will not be able to sell is cookies.
You know, I'm not an intellectual property attorney, but now that issue has been flagged for us, and we will look into that.
Okay. Only the people who know Mrs. Berry's cookies in Kona get that, but
Yeah.
you know.
And can I make one final note?
You may.
And it goes to a comment that Commissioner Okuda made earlier with respect to the declaratory ruling from back in 1983, 83-8. You know, and there's nothing we need to parse out on here amongst all this, but I want to make sure it's on the record that there has been some verbiage change to the definition of farm dwelling since then. It's similar in a lot of respects, but just wanted to clarify that for the record.
Okay, thank you. Anything further for Mr. Simon, commissioners? If not, Mr. Mukai?
No, nothing further, Mr. Chair, other than our submission.
Okay, any questions for the county, commissioners? Closing, Mr. Yee?
Thank you. Very briefly, the Office of Planning supports the reclassification. We note that in 1977, almost 57 acres, I think, were reclassified of surrounding property from conservation to agriculture. This property would have been included in that 1977 decision, except the owners couldn't be found. So for the Office of Planning, one of the factors we looked at is we had to weigh both the importance of recognizing the value in the finality of decision making, as well as recognizing and respecting prior decisions, and also as well to make sure that any decision is consistent with the LUC's constitutional and legal obligations. So in the 1977 decision, all of these surrounding properties were moved from conservation into agriculture. No conditions were imposed. That was just the decision that was made back then. You know, that might not be the decision we would have made today, but we have to respect, I think, the decision that was made and accept the choices that were done by the prior commission. So when we apply it to this case, respecting and understanding that the case does need to comply with legal and constitutional obligations, the Office of Planning is only recommending two relatively small conditions consistent with their finding of no significant impact representations, and as well, of course, as the LUC standard conditions, and believe that that would be satisfactory to meet the LUC's constitutional legal obligations. We understand and share some of the concerns that were raised by the commissioners. The Office of Planning certainly stands behind and supports DR 83-8's determination as to the definition of a farm dwelling, and recognize the larger question that exists in the state on this question. We don't think, though, that this case is where the problem needs to be solved. It is one parcel in a much larger area, which has already been reclassified. As I said, reclassified without conditions. So in light of these facts, we think that for this particular case, we think only two conditions plus the standard LUC condition should be imposed, and that we should rely upon the county to ensure that the property complies with Chapter 205, as well as any other legal and constitutional obligations that may arise. We accept and appreciate the comments that are raised about farm dwellings, and if it is a shot across the bow for any future cases, we welcome it. But in this particular case, we support the petition. It should be approved. Thank you.
Just because of the extensive final argument from well, not extensive, but the final argument for Mr. Yee. I'm going to give Mr. Simon any opportunity to rebut if he wishes to.
Nothing to rebut. Just, again, want to thank OP. I think Mr. Yee kind of echoed what my comment was, that while there might be problems elsewhere, I don't think that should be used against the petitioners here, who have made very firm representations to comply with the law as it sits here today and as it may be in the future. So nothing further. Thank you very much.
Okay, thank you very much. With that, sorry, any questions for Mr. Yee from the commissioners? Anyone? With that, and given that the parties have completed their presentations and final arguments before the Land Use Commission, I will declare the evidentiary portion of this proceeding to have been completed, subject to the receipt of any follow-up reports or answers that may have been requested. I direct the parties to draft their individual proposed findings of fact, conclusions of law, and decision in order based upon the record in this docket, and serve the same upon each other and the commission. The proposed findings of fact must reference the witness as well as the date, page, and line numbers of the transcripts to verify your facts. In addition to the transcripts, the exhibits in evidence should also be referenced. Please contact our court reporter to arrange for copies of today's transcript. I will note for the parties that the commission, Mr. Yee, you're muted, Mr. Yee.
You can finish, but I wanted to ask for permission to not file findings of fact, conclusions of law, and decision order. We are in agreement with the proposed reclassification. And ask the petitioner to pick one and allow the parties to submit comments.
You can certainly waive. Yeah. Okay.
And same thing with the County of Hawaii Department of Planning. Thank you.
Okay. Thank you. To continue. In addition to the transcript, the exhibits and evidence should also be referenced. You can obtain the transcript from our court reporter. The parties should all note the commission has standard conditions. We would like the parties to include these in preparing the proposed orders. To the degree that the parties are preparing proposed orders, a copy of the standard conditions may be obtained from the commission staff. I recommend that the parties, particularly the petitioner, consult with the commission staff early in the process to ensure the technical and non-substantive formatting protocols observed by the commission are adhered to. As I was suggesting, if any, as Mr. Yee anticipated, if any of the parties wish to stipulate any of the proposed portions of findings of fact, conclusions, law, of decision, and order, they are encouraged to do so. Deadlines. If you are filing partially or full stipulations or your own orders, you should serve these no later than March 8th on the commission. Any comments, stipulations, or objections to the parties' respective proposals should be filed with the commission and served upon the other parties no later than the close of business on March 12th. The deadline for any rebuttals will be March 17th. Are there any questions from the parties with respect to our procedure, starting with Mr. Simon?
None from petitioner. Thank you, Chair.
Mr. Mukai?
Nothing further, Chair.
Anything further, Mr. Yee?
Would it be possible to have, to get a few more days on the review of their proposed findings?
I'm trying to expedite this so that we can take this up again on March 24th. So okay. This is really the schedule that we need to adhere to.
All right, then we will just ask if we can get a courtesy copy of a draft, which might not be the final, from petitioner as early as possible. Thank you.
Can we work with that, Mr. Simon?
Yes, Chair. I will work to get a draft as soon as possible. I can't make any promises on timing, but I'll certainly work with the Office of Planning and their counsel to get them something as soon as we can.
Okay, thank you. Anything further?
Mr. Simon, same request from the County of Hawaii.
Yeah, as well as for planning and Corp Counsel as well.
Thank you, Mr. Mukai. Thank you to everyone for your efficiency and to the diligence of my fellow volunteer commissioners in your questioning. Mr. Ordenker, is there anything further regarding procedures?
Mr. Chair, that concludes the business for the day, I believe.
Okay. Is there any further business or comments from any of the parties? I'd like to extend my thanks to the petitioner, to the Berries, and we look forward to it. Mr. Kern?
Yeah, Mr. Chair, thank you. Just brief latitude. Just want to make sure the berries are covered. If this goes through, make sure that they come talk to the planning department and cover any SMA issues prior to any ground disturbance or anything like that. Oftentimes folks will think they got an approval or it's okay, and they go down there inadvertently, and next thing you know, we get a complaint, we're having to issue an NOV on it. So that's my, just want to throw that out there so everyone's above board on that. Thank you.
Thank you, Director Kern. Any further business, commissioners? Seeing none, I wish you well and declare this meeting adjourned.